Hello guys. So in this video I will be starting administrative law, and it is the fifth part of chapter 2 which we were doing, that is topics of law. Let's begin this unit also. History tells us that societies and civilizations can survive without science and technology but not without administration. Administrative law aims to ensure that policies, rules, regulation, and legislation formulated for public good are not misused. So, it is just a background you may have also done in class 11 legal studies. Chapter 1 or 2 it was that how societies and civilizations were structured. So basically, history tells that societies can survive if there is no science and technology, because at that time when the science and technology was not so developed, people used to survive. Those early human beings story we all have heard about, how they invented about fire, how they invented those boats or those wood pieces, right? So they knew how to survive without science and technology. They knew how to survive without all those mobile phones, fans, ACs, and all that stuff. So all these things are related to science and technology. Without that, they were able to survive, but without some leadership qualities, because they moved in groups. So without some leadership qualities, or without proper administration, survival is not possible. So administration law is that how some rules, regulations, or some policies, some provisions, some principles, if implemented in the society for public welfare, then there would be proper administration, efficient administration. And if these policies are made, then it has to be ensured that all the policies, and due to these policies the powers which are conferred upon few people, all that is not misused. Administrative law and constitutional law key differences. Before 21st century, administrative law was considered a part of constitutional law. So here, before 21st century, we considered administrative law to be a part of constitutional law, but then there has been a clear distinction set up between these two. Administrative law aims to keep a check on actions of government when dealing with procedures affecting the rights of citizens. So whenever there is something, any law, any legislation by the government, and that interferes with the fundamental rights of the citizens, then the administrative law comes into being. It keeps a check on the government policies and on the actions of government. On the other hand, constitutional law clarifies the scope of rights and duties of citizens and government. As we know what constitution contains about, all the constitution provisions and principles are about rights, duties of government, of states, powers that different organs of government have, different institutions or organs of government, right? All these things are only mentioned in the constitution, and that too you may have studied about in class 11 chapter 4 unit 1, right? So that all contains what constitution is about. So constitutional law is nothing but the constitution which gives a very elaborated version of every provision, principle, rule, or powers or duties or functions that the citizens have and that the government and its various organ has. For example, how elections are held, parliament is formed, powers of parliament, different branches of state, that is government, are essentially the key questions in scheme of any democratic constitution. If it is obviously democracy, then how will the elections be held, after how much regular period of time, how would be the house of people, that is parliament, what would be its duties and functions, what would be its powers, what would be the power of the head of the state, what will be the different organs of the government, whether it will be a federal or unitary government. All those things are the key questions, key matters. Whereas when a minister is finally appointed and his actions affect the general public good, then we can categorize the study of these actions as a core constituent of administrative law. So after elections are held, minister is appointed and then he performs the duties which are given to him as per the post on which he is sitting. So according to that, whatever his actions or his reactions are, means whatever he does sitting on that post, on that rank, and that affects the public welfare in a positive or in a negative way, then those actions can be categorized as a part of administrative law, because now he is a part of administration branch, right? Minister is a part of administration branch, so whatever actions he is taking for the public good or for the general public welfare, that is how we categorize his actions as administrative law. Objections to growth of administrative law. Throughout the growth of human civilization post 16th century, in times when laissez-faire, French term meaning allowed to do, policy of minimum governmental interference in economic affairs of individuals and society, economy had just entered and in golden Victorian era, the scope of government intervention has always been in question. So after 16th century, throughout all the times when economy was just means economy had just started to begin, and in the golden Victorian era, now the scope of government was a key point of matter, or it was a hotly debated matter, that what would be the government's role or government's part in the economy. One line of argument was that government should not merely watch the plight of its citizens and instead come forward and protect the less privileged. This was the era of paternalism. So please mark what is paternalism, maternalism. These all are very important terms which may be asked. So paternalism, according to it, the thing is that government should not only keep an eye and watch from a distance that what all its citizens or its subjects or the people of its nation are suffering from, what their condition is. Government should not watch it only from a distance, but it should come forward and do something that will help those less privileged or disadvantaged people, and the government should take steps to protect and to uplift their condition. So this is according to paternalism. Another line of thought was that it is not just protection which is the dharma of government, means which is the duty of government. As the mother takes care of her child, state must take care of its citizens, and with this evolved the era of maternalism, because we said that as mother takes care, so that is from mother we took the term maternalism, and then this term came into being, that as a mother protects, not only protects, takes care, in the same way the state, that is the government, should take care of the countrymen. In 21st century, another shade of opinion evolved which suggested that people must be left free, as importance was given to individual freedom. It was expected that governmental administration will recede, while the state's function as a businessman entrepreneur has decreased, but state's function as a provider, facilitator, regulator still occupies a very high position in public order, especially in the context of developing and least developed countries. Okay, so in 21st century, by the time it came, so this was post 16th century when we saw paternalism and maternalism. In 21st century, we came on to, as we progressed, we thought that we need some privacy, we need some individual freedom, and with that a concept evolved in which it was said that now government need not to be with all the people all the time. Government need not to be the mother or father of the citizens, but now the citizens are grown up kids and they need to be left alone. They must have their individual freedom or some sort of privacy, and after this it was believed that governmental role will be lessened or it will stop. State's function as a businessman was decreased, but still it was a provider, a facilitator of the various facilities, of the various uh, provisions that it must provide to the general people. And it was very important role of the government till now even, that it should provide all the basic facilities, all the basic facilities of life to its citizens, and it should take care, it should facilitate, it should regulate that how the distribution of resources or wealth is done among the citizens. So all these things are still a part of function of the government only, or of those people who are sitting in power and who are administrating over us, or who are a part of the administrative branch. Their function is to provide the common people, the citizens of the nation, with the basic facilities, and to regulate that how those facilities will be distributed and how it will reach the masses and to each and every person without being any discriminative part. A twofold criticism with aid of philosophical concepts was directed against growth of administrative law in England, while rule of law was weapon used in US. Doctrine propounded to check the growth of administrative law was separation of powers. So in England, what was happened? Rule of law tha, the means whatever is written in the law, those rules will only be done, and law will be heading over the state. So that was the thing. But in US, now administrative law was growing to such an extent that powers was separated among various branches of the government. Reasons for growth, development and study of administrative law. In 21st century, developing countries like India expect a very proactive state for their own welfare. Means they need a very active government so that it may think about the people, the common citizens, the poor people, or you can say the less privileged or disadvantaged sections of the society, and to uplift their condition, the government must take steps forward, and they may make some policies or provisions that will help to improve the plight of the poor people or the disadvantaged sections of the society, and also for the well-off people, to uplift them, also to provide them the necessary facilities, and means to make policies for the welfare of the whole nation. And actively participating, that should be a government, basically in developing and less developed countries. And India is a developing country, as you all know. So we expect a very active government that will think about the nation's welfare. The welfare questioned in administration cannot solely be vested in legislature. This is impossible in practical terms, as governance as a whole will cease to function if for all kinds of administrative action sanction of legislation is compulsorily required. That means we not only completely leave this question of welfare ऑन लेजिस्लेचर पार्ट, कम्प्लीटली हम लेजिस्लेचर पर ये नहीं लाद सकते कि सिर्फ आप ही को वेलफेयर का सोचना है. इट इज़ इम्पॉसिबल कि इतने बड़े नेशन का गवर्नेंस सिस्टम सिर्फ एक पार्ट या एक ऑर्गन देखे. सो फॉर दैट कि हर एक चीज़ के लिए हमें परमिशन लेनी पड़ेगी लेजिस्लेचर के लिए, क्योंकि वेलफेयर का पूरा डिपार्टमेंट उसके पास है. सो दैट इज़ रॉन्ग, बिकॉज नाउ द गवर्नेंस एज अ होल विल stop to function if all kinds of action, for all kinds of action we have to take permission or sanction of the legislature. This need is often pointed out as single most important factor which has led to growth of administrative law. क्योंकि हर एक चीज़ के लिए हम एक सिंगल डिपार्टमेंट पर निर्भर नहीं हो सकते, हर बार उससे नहीं पूछ सकते. एज अ होल पूरे गवर्नेंस को करने के लिए हम हर बार एक ही डिपार्टमेंट से बार बार पूछें, उसके अलावा हम काम ही ना कर पाएँ कुछ. सो दैट इज़ रॉन्ग. And that is why it was the most important factor that why this administrative law came into being and why it had grown. Moreover, if we were to examine the scheme of our constitution while defining state, Article 12 of Indian Constitution mentions any other authority. Hence, authority is created by law authorities which are agencies and instrumentalities of state, or authorities which are essentially discharging public functions which have an impact on common people, are all part of the state. State is any authority which is duly established or created by law, and it has a funding of 50% or more than 50% from the government. That is basically a state. Okay, and so under state we have various authorities that may be created by law, that may be such a huge authority, or that have an impact on general people, and that discharge some public functions, that are doing some things or some actions which are resulting in the welfare of the sections of society. So any authority which is duly created by law, an NGO funded by the government, can also be a part of state. As I told you, funded by government, 50% or more fund by the government, any organ, that is state. Types of administrative action. Administrative action can be of 4 types. Administrative legislative action, wherein the administration puts on hat of legislature simply because it is not practically possible for any legislature in world to legislate so perfectly that their laws are able to cover the possibility of all kinds of conflicts which can rise out of a decision, even if members of parliament sit for all days in a year. Administrative legislation action includes rule-making action as well as delegated legislation. As explained in section above, many decisions can be taken only by the grassroots authorities, and there are practical limitations on every legislative organ, making it impossible to legislate on all kinds of possibilities. So administrative legislative action means if the whole of administration is put upon on part of only legislature, then it will be impossible to take all the actions, and because it is nobody is perfect, right? और legislature एक as an organ में कुछ humans ही तो होंगे जो work करेंगे, एंड ज़रूरी नहीं कि वो ह्यूमंस सारे एरियाज और सारे एरियाज में परफेक्ट हों, वो सारे डिसीजंस ले सकें। एक ही डिपार्टमेंट में नहीं ज़रूरी है कि सारे ऐसे लोगों, एज वी जॉइन दैट सेपरेशन ऑफ पास्ट चैप्टर, ज़रूरी नहीं कि एक ही बंदे में सारी क्वालिटीज़ हो, वो हर एक चीज़ को देख ले। आज इस पर्सन में ये प्रॉब्लम है, इन 2 लोग इस मैटर को लेकर लड़ रहे थे, तो चलो आज इस पर एक रूल बनाते हैं, ठीक है, बना दिया। लेकिन और 2 लोग किस बात पर लड़ रहे थे वो आप इमेजिन नहीं कर सकते। हाँ, ये पॉसिबल नहीं है कि अगर 150 करोड़ इंडियंस हैं तो उन हर 150 करोड़ आदमियों की प्रॉब्लम आपको पता हो और उन हर चीज़ के लिए आप एक लेजिस्लेशन बनाएं। ये प्रैक्टिकली पॉसिबल ही नहीं है। इतनी सारी 150 करोड़ लोगों की प्रॉब्लम 150 करोड़ से भी ज़्यादा होगी। तो अगर आप साल के 365 दिन भी पार्लियामेंट में सेशन लगा लें, डिबेट कर लें, तब भी हर एक मैटर पर रूल बने, ये प्रैक्टिकली पॉसिबल नहीं है। पहली बात तो कोई 365 दिन काम कर ही नहीं सकता, वो लोग 365 दिन बैठ ही नहीं सकते। दूसरी बात, ये पॉसिबल नहीं है कि फॉर ऑल काइंड्स ऑफ कॉन्फ्लिक्ट्स दैट मे अराइज अमंग द कॉमन पीपल टू मेक अ लेजिस्लेशन अपॉन ऑल दोज कॉन्फ्लिक्ट्स, इट इज़ नॉट प्रैक्टिकली पॉसिबल। ये पॉसिबल ही नहीं है कि आप उन सारी चीज़ों को कवर करके एक लेजिस्लेशन फ्रेम कर सकें। इसीलिए एक पर्टिकुलर ऑर्गन पर सारा भार डाल देना इज नॉट अ गुड गवर्नेंस सिस्टम। एडमिनिस्ट्रेटिव लेजिस्लेटिव एक्शन में रूल बनाना भी होगा और रूल को इम्प्लीमेंट करवाना भी होगा। You also need to act as a representative of the common people. You also need to make and implement those rules. Many decisions can be taken at the root level. जैसे हमारे पंचायती राज सिस्टम है एट द रूरल लेवल, फिर हमारे पास डिस्ट्रिक्ट कोर्ट्स हैं एट द डिस्ट्रिक्ट लेवल। तो ये सब चीज़ें अगर ना होती, सिर्फ एक डायरेक्ट ऑर्गन होता, तो बहुत मुश्किल हो जाती ना चीज़ें। अभी हमें पता है कि जुडिशरी है, यहाँ पे हमारा कोई भी डिस्प्यूट होगा हम यहाँ पे जाएंगे। अगर ये जुडिशरी ना होती, एग्जीक्यूटिव ना होता, हमें सारा कुछ लेजिस्लेचर के पास करना होता। तो कैन यू अंडरस्टैंड द बर्डन अपॉन दोज पीपल? Are you getting my point? So there are limitations on every legislative organ. Each organ cannot step into the shoes of another organ what they are doing. Powers and functions of those are separated. So it is not there is no perfect administration possible if you just put on all the burden of all the work on legislature only. It is impossible to legislate on all kinds of possibilities. Next is quasi judicial action or administrative adjudicatory action. In these cases, administration performs functions which can be put under judicial domain as there is some adjudication on legal rights of individuals involved in the matter. So as I said, अगर judiciary भी ना होती तब भी हमें legislator के पास जाना पड़ता. So in this case, quasi-judicial action, in this case, the administration performs those functions which were actually the part of functions of judiciary. Because obviously, if two people are living together, there will be a dispute between them, and there will be some dispute or violation of any right of a person, and for that they will come to court. So to adjudicate, to solve that matter, now administration has to perform the function. Simply administrative action of all the actions undertaken by administrative authorities other than the two types mentioned before. The rest are called administrative actions which essentially deal with execution of crucial administrative decisions. So simply हाँ ये है basic and straight away the administrative actions apart from judicial actions or apart from making and implementing all those legislative actions, the rest are known as administrative actions which deal with the execution, means to implement those administrative decisions. जो भी law frame किया उसके अलावा, see, administration means framing laws, adjudicating the dispute, that was essentially judiciary. Framing law is obviously legislator only, but now you have to implement or execute them also. For that we have execution, right? Okay, so all the other actions apart from making laws, apart from adjudicating disputes, अब जो चीज़ें बची, that are administrative actions, which is essentially that how those decisions will be implemented. जो भी decision members of parliament ने लिए, अब उसको implement कैसे किया जाए, उसको जनरल पब्लिक तक कैसे पहुंचाया जाए. डिसीजन लेकर ही तो काम ख़त्म नहीं हो जाता ना, उसको implement करना भी होता है. तो उसको कैसे इम्प्लीमेंट, कैसे एग्जीक्यूट करेंगे. जब हमने कोई प्लान बनाया तो उस प्लान को एग्जीक्यूट कैसे करना है, किस तरीके से उस प्लान को रन करना है. तो दैट इज़ ऑल अ पार्ट ऑफ एडमिनिस्ट्रेटिव, सिंपली एडमिनिस्ट्रेटिव एक्शन. Ministerial action. In administrative action, there is discretion to administrative authority, that is, the authority has right to exercise his or her understanding and discretion in dealing with the matter, but in those actions which are copybook action and no discretion is vested with authority, that is, there only one way of performing that action, such action will be called purely administrative action or ministerial action. So there are some matters in which the minister or the authorities can exercise upon their own brain or their own understanding and take a decision upon the matter. They can deal with the matter in their own way as per they think it is right. बट इन सम केसेस जो डिट्टू होते हैं पहले के, ठीक है, मतलब कॉपी बुक एकदम कॉपी पेस्ट होते हैं ऑफ द प्रीवियस एक्शंस, और जहाँ पर अथॉरिटी के पास कोई पावर नहीं होती कि वो इस तरीके के अलावा कोई दूसरा तरीका सोचे. कुछ डिसीजंस होते हैं जहाँ पे आप अपने दिमाग के हिसाब से, अपनी अंडरस्टैंडिंग, सही गलत के अंडरस्टैंडिंग के हिसाब से मैटर के साथ डील कर सकते हैं. लेकिन कुछ एक्शंस होते हैं जो पहले हो चुके हैं, पहले में उस बंदे ने इसी तरीके से एक्ट किया था और अब वैसा ही एक सिचुएशन आपके सामने आ गई है, और यहाँ पर कोई स्कोप नहीं है कि आप अपना दिमाग लगाएं, तो और आपके पास कोई पावर भी नहीं है यहाँ पर कि आप अपने डिस्क्रिशन के हिसाब से काम करें. वही एक तरीका है जो उस समय उस बंदे ने किया था. सो यू have to go forward with that same action. So that is purely administrative action or ministerial action. For example, the statute which created a university mandates that university open a bank account with a given bank Y. This is a purely administrative action as there is no scope of any discretion in its performance. So यहाँ पर एक statute, एक order निकाला government ने that if you create a university, if any person or a group of people now make up a mind to set up a university, so there is a rule that if you are creating a university, then that university with the name of that institute or university, you have to open a bank account with this particular bank. Why only? So now there is no scope of the understanding of brain or mind of that person who is opening the university. There is no scope for you to think upon it. You have opened the university, now you need to create a bank account with this bank. Why? आपके पास कोई स्कोप ही नहीं है इधर उधर का कुछ सोचने का. तो ये है एक मिनिस्ट्रियल एक्शन वेयर देयर इज नो स्कोप ऑफ एनी सॉर्ट ऑफ मेकिंग डिसीजन अपॉन योर ओन डिस्क्रिशन. Hence, as is clear from aforesaid classification, it would be wrong to say that administrative law deals only with execution of policies or that it is only procedural in nature. In contemporary times, it can be called a full-fledged discipline which is very substantive in nature. Means it functions, ये adjudicate भी कर सकता है, ये इम्प्लीमेंट भी कर सकता है, डिसीजन ले भी सकता है, इम्प्लीमेंट भी कर सकता है. सो इट इज़ अ फुल फ्लेज्ड, फुल डेवलप्ड डिसिप्लिन जो कि हर चीज़ को टैकल कर सकता है. इट इज़ नॉट ओनली विद द एग्जीक्यूशन ऑफ पॉलिसीज. Suppose there is a dispute regarding grant of scholarship to a person A over B. B thinks he deserved the scholarship and goes to court. Court will not ask the university why did you grant the scholarship to A. On other hand, it will only ask how and on what grounds have you given the scholarship to A. If university argues that grant has been given just like that and does not show the rationale, such administrative action is bad in law and deserves to be set aside. However, if it is shown that it was given on the basis of academic merit, the court is unlikely to interfere. तो जाहिर सी बात है, if you see, law in India and law in other countries also work on proof. So if the court asks that on what grounds you have given the scholarship to A, because B thinks that he is more deserved than A to get the scholarship, then why have you given or on what grounds you have granted the scholarship to A? And if university in this situation is able to give the proof that these are the academic or co-curricular records of these two people A and B, तो यहाँ पर आप देख सकते हैं A ज़्यादा well off है B से, so we have given the scholarship on these grounds. तो अगर वो अपने grounds को prove कर सकते हैं तो ठीक है, तो कोर्ट कहेगा कि हाँ सही बात है. द कोर्ट विल नॉट इंटरफेयर इन सच अ मैटर. बट इफ़ यूनिवर्सिटी से ऐसे ही मन कर रहा था, ए सुंदर दिख रहा था तो ए को दे दिया, ए थोड़ा अच्छी पर्सनैलिटी है तो उसको दे दिया. सो इफ़ इट इज़ लाइक एवं ही दे दिया, जस्ट लाइक दैट आई हैव गिवन इट टू ए, तो ये गलत है. दिस इज़ नॉट अ रीज़न, दिस इज़ नॉट अ रीजनेबल आर्ग्यूमेंट. सो सच थिंग्स आर कंसिडर्ड टू बी बैड इन लॉ and the whole case will be set aside. उसको फेंक दिया जाएगा कि नहीं ये इस मैटर को हम नहीं ले सकते, फालतू वाला बयान दे रहे हैं ये. नाउ द स्कोप ऑफ एडमिनिस्ट्रेटिव लॉ, नेक्स्ट वीडियो.